All right. Welcome to episode 2 of Compliance is Sexy, or a day in the life of a real estate broker. Hey, everybody, I'm Jason Lopez. I am the managing broker with Real Broker in California, and I want to welcome everyone back. So, in the first episode, I talked about what the role of a managing broker, designated broker, broker of record is, and how we kind of operate in the background behind the scenes. To expand on that just a little bit, I like to think of it as an extra set of eyes on all of the transactions that the real estate agents are doing. Often real estate agents manage their own transaction files, meaning they're responsible for getting all the documents signed, getting everything done based on the timeframes established in the contract. Often, however, they may have what's known as a transaction coordinator, whose responsibility is to kind of be the liaison between the agents, maybe the other agent's transaction coordinator, the escrow officer, the lender, right? And their role is to basically make sure all of the documents are gathered and submitted to the broker, me, for review. Now, one of the cool things as the managing broker, and I understand that like reviewing files might seem super painful and tedious to some of you, and it can be, I'm not going to lie, but the reality is because of our technology platform, it's actually a pretty efficient process. I'm able to review 60, 70, 80 files a day. And the cool thing is, once we kind of have a pipeline established, and we've got over 700 agents that work for me in California, and there are various stages of their transaction. So it's pretty common when I go into review files that, there might be one or two documents for me to look at in each file. Of course, we always have new transactions that are just being started. So I might have 8 or 10 documents, multi-pages in those documents that I need to look at as well. But through our technology platform, it's pretty efficient to get through and be able to see a lot of files. Now, what's cool about it for me is if that agent is using a transaction coordinator and we've worked together, they've been working with our agents for a while, we kind of have some trust there in terms of I know how they do things. They understand what our process is. If there's outstanding documents and, I let them know, hey, we're missing this or that, they'll respond and say, hey, it's in process, where it's out for signatures. We're going to get that uploaded right away. So you kind of develop a cadence and a trust factor with those transaction coordinators or the agent if they're doing their own files. As the managing broker, as I mentioned in the first episode, everything the agents say and do might as well be me saying or doing those things. So for me to actually have eyes on every single transaction is very beneficial. It allows me to kind of have my finger on the pulse of what's going on and to see how the agents are actually conducting business, how they're representing their clients. And that satisfies a Department of Real Estate requirement here in California, which is to actively supervise the agents on my license. So I appreciate the opportunity to be able to go and actually see every single file. So what I wanted to share with you today are a couple of common things I find when I'm doing the file review. And these are two things that are particularly common in the purchase agreement. Now, one of the things I want to mention about the purchase agreement is it is a living and breathing document. We will talk more about the purchase agreement in coming episodes, various aspects of it. But I want to mention that all of the forms and contracts, disclosures we use in California are all standardized, and they're provided through a platform called ZipForm, which at one time was actually owned by the California Association of Realtors. They review the forms several times a year. We actually have a standard forms committee, which is one of our committees with the California Association of Realtors. And based on what's happening out in the real world, those forms and contracts are updated and revised a couple of times a year. The last revision we had, which I believe was back in December of 2021, was a major overhaul of the purchase agreement. It went from 14 pages to 16 pages, just the contract itself, with the initial addenda that goes along with the contract. It's probably 30 pages. It's not uncommon after a file is complete that there's well over 100 or even a couple of hundred pages of documents in a transaction file, depending on the reports and other stuff that may be part of that particular transaction. So with this major overhaul going to 16 pages, not only was more stuff added to the purchase agreement, things were moved around, and it was kind of redesigned. So it took a little bit of training and practice to make sure the agents were up to speed with that. There's one particular issue that jumps out when I'm reviewing files often that I want to talk about with you today. I also want to mention quickly that a lot of how offers are structured is based on local custom. So for example, I'm based in San Diego, California. I have, again, about 750 agents all over the state, and how they do things in Northern California different than how we do things in Southern California. And there's some nuance in certain regions. I'll give you an example. The issue I want to talk about today has to do with the mediation and arbitration clause in the purchase agreement. In the Fresno area, the Central Valley area, it's pretty common that the parties, the buyer and seller, do not elect to include the arbitration clause in their agreements. And in other parts of the states, they always include the arbitration clause. So there's some language in the arbitration clause that states if the buyer and seller agree to arbitration, they are giving up their rights to a jury trial if something comes up between the parties. Now, remember, the purchase offer is an agreement between the buyer and the seller. The real estate agents and brokers are not a party to that contract. So mediation and arbitration is specifically addressing issues, problems that come up between the buyer and the seller. Okay, here's how the contract is set up. Mediation is agreed on by default. It's just the plain language part of the contract that just says, hey, if any problems come up, the first thing that's going to happen between the parties is you're going to mediate and try to resolve that solution. Often that is very workable, and we do find a solution during that mediation period. Okay, I always say with mediation, both parties go away kind of feeling like they lost because they're going to have to give a little bit ultimately to get the resolution that they're looking for. If mediation is not successful in resolving the issue, then that next step, if they selected arbitration, would actually be to go to an arbitration hearing. And there is language in the contract about who that arbiter could be or should be. It should be a retired judge or somebody like that. And it is very much like a trial. It's just done outside of the court system. Okay. And so they will go to arbitration if mediation didn't solve, if that was their choice. And it is a binding decision. Okay. Just like a jury, bringing down a verdict would be binding. It's the same kind of thing. Now, people opt for arbitration over a jury trial for lots of reasons. Often it's faster. It could be less expensive. And again, because it's binding, the winning party may be able to be rewarded fees and other costs that they might have incurred during that arbitration period as well. Okay. Now, if they choose not to go to arbitration, they would not initial the arbitration clause. Both parties have to initial. I'm going to come back to that in a minute. But if they elect not to go to arbitration, they would go to court. It would settle it there. If they elected arbitration, there are some issues or reasons why it wouldn't go to arbitration, even though they selected arbitration and a problem came up. Those reasons would be if it's a dispute about money and the amount of money falls into the small claims realm, then they would just go to small claims court. They wouldn't have to go to arbitration, even if they selected arbitration. If there's a probate issue, that would be how you would handle it through the probate court versus arbitration. And if there is an unlawful detainer that was filed for some reason, then that would be settled through the courts as well. So there could be a couple of reasons why it wouldn't go to arbitration if in fact the parties selected arbitration. Okay. So that could be how it would be worked out with the arbitration clause. Now, what I see that happens quite often is, again, 16 pages in the purchase agreement, lots of places for the buyers and sellers to initial. They have to initial at the bottom of every page of the purchase agreement. And then there's a few different additional places they need to initial along the way, and then obviously sign the contract as well. The arbitration clause is an area where they have to initial. Both parties need to initial that if they agree to go to arbitration. What happens, however, if one party, let's say the buyer, initials the arbitration and the seller does not? What do we do then? Well, when I see that, which again, it's not uncommon, probably one or two out of every files I review when I'm looking at the purchase agreement, only one party has initialed the arbitration clause. So what I always do then is I'll look to see if there's a counter offer that has been utilized in the transaction. So the buyer made an offer, they signed the arbitration, the seller did not, and maybe they meant to and they missed it. It was an oversight, or maybe they intentionally didn't want to sign it. But if there's and then let's say they make a counter offer, the sellers make a counter offer for some other terms and things like that. Well, if there's a counter offer, then we don't need any resolution on only if one party initialed the arbitration clause or not. And the reason is there is language in the counteroffer that says if there are any clauses not initialed by both parties in the purchase agreement, then those clauses are removed from the agreement. Okay, so the counteroffer, without adding anything in, it's already in the counteroffer. It's boilerplate language in the counteroffer. If only one party initialed that arbitration, or there's a couple other clauses, then it wouldn't be part of the agreement just based on the language in the counteroffer. Now they could make a reference in the counteroffer that the other party is going to sign the arbitration, right? So if I see only one party has initialed arbitration and there is not a counteroffer, then I'm going to bounce that back to the agent. I'm going to say, hey, only one party initialed arbitration. We need clarification. We need to know what is going to happen, how it's going to be handled if an issue, in fact, does come up at some point down the road. So they're going to need to either do a counteroffer to clarify, maybe use an addendum form, which we can do to clarify whether or not the arbitration clause is going to be made part of the agreement or not. Okay, so arbitration could be very important. Now, 99% of the time, the transactions are, well, I'm not going to say smooth. There's always issues that come up, but overwhelming majority of the time they close and everybody goes away happy. The new buyer moves into the house, the seller moves on down the road to continue on with their life and their new journey, and everything's fine and well. But if an issue were to come up and we didn't have clarification on that, then it could be a little bit of a sticky issue to figure out how we're going to resolve that. And probably it would end up in court, which nobody probably wants. So arbitration is one thing that I see where sometimes it doesn't get covered all the way. Now, I mentioned in Fresno, they very rarely use the arbitration. And so most of the contracts I review from that region, nobody's initialed the arbitration. They've just agreed not to use it. And I actually asked some of our agents in Fresno why they don't use the arbitration clause. Again, a lot of it is just based on local custom, right? But I just found it curious that in that particular region, they almost never use the arbitration clause. And I heard back from several of them, and they told me that years ago, there was an attorney that used to do these trainings about the purchase agreement. And one of the things he used to teach or talk about was, listen, when it comes to the arbitration opportunity, why would you want to give up your rights to go to court? And it's interesting. I found in my career that oftentimes the only people who don't want to initial and invoke the arbitration clause are attorneys, right? Because they don't want to give up their rights. Now, it's not our job as agents or brokers to give legal advice, right? If they have questions about anything in the contract, we always recommend that they seek the proper advice from an attorney that's experienced in that matter. However, it is our responsibility to make sure that they read the contract and understand what they're about to sign or initial. And if they don't, then we need to pass it off to an attorney and let them help answer those questions. The other issue with the contract that I see a lot are buyers removing contingencies with the offer. Okay, think of contingencies as protection. These are protectionary clauses that are going to protect the buyer's rights or the seller's rights, depending, and could dictate how things are going to happen with that contract as you process through the transaction. The purchase agreement will spell out not only the price that the buyer's willing to pay, but also all of the terms and the timeframes that everybody agrees to meet certain obligations, these contingencies, right? So default in the contract, seller has 7 days to provide all of their disclosure information, everything they know about the property. On occasion, a seller will be exempt from utilizing the actual disclosure forms. However, they're not exempt from making disclosures about material facts they actually know about. Okay, that's one thing I always mention. But they have 7 days to do that. And then after receipt, the buyer has a certain amount of time, 5 days, I believe, to review that documentation. And if they're cool with it, they can remove that inspection contingency, right? Things of that nature. There are a few things when a buyer waives contingencies. Maybe they waive the inspection contingency or the loan contingency, things that we don't necessarily recommend, but sometimes depending on the competitive aspect of the market, they may have to do things like that. But there are some statutory requirements that cannot be waived. Okay, these are legal issues that need to be incorporated and cannot be waived. One of them is what we call the natural hazard disclosure. What the natural hazard disclosure does is it shows where that property is in relation to potential natural hazards, fire zones, earthquake, fault line areas, floodplains, things of that nature. So there's actually companies that provide these reports, and they use maps from state and local sources that will say, hey, based on this address, 1234 Main Street in San Diego, this home is in these natural hazard areas, right? That's a statutory disclosure that needs to be made from the seller to the buyer. When that law went into effect, like overnight, this cottage industry sprung up because nobody knows where to get that information. So there, these companies, a lot of them are part of the title insurance companies that we work with because they've got all the property data, so they can pull those maps and let people know. But the NHD, natural hazard disclosure, is a statutory disclosure that can't be waived. So again, important that you understand what you're reading, what you're reviewing, what you're signing. And again, demonstrating who you work with matters. So if you're a client, the agent, a buyer or seller, the agent you work with is really important. And also just as important, and maybe even more so, is the broker that they work with. So again, a little sneak behind the curtain to give you a little insight into what a managing broker does in terms of dealing with purchase agreements and contracts and disclosures. We'll talk a lot more about this stuff in future episodes. But until then, I appreciate you tuning in, and we'll catch up with everyone real soon. Have a great rest of your day. Take care.